Hello and good afternoon to everyone. My name is Philip Hoddell and I'm the chairman at Burkitt Long. I'm delighted to welcome you to this Wednesday webinar. Burkitt Long are offering fortnightly webinars on a range of different legal subjects. In the coming weeks, we'll be providing updates on employment law and commercial rent arrears, and we'll then have a break for summer before returning in September to look at tax and estate planning across the generations. If you're interested in any of our webinars, please sign up at www.burkittlong.co.uk/events. Today's webinar is being presented by Peter Allen, Head of Construction Law at Burkitt Long. Peter is recognised as a leading authority in this field, and he'll be looking at the new Building Safety Act. I will now hand over to him without further ado. Thank you.
Thank you, Philip. As Philip mentioned, I'm Peter Allen and I'm head of the construction team here at Burkitt Long, and I'm going to talk about the imminent changes brought about by the Building Safety Act. We are taking questions at the end, so please do make use of the question and answer facility and send your questions in as you think of them, and we will try to get through to as many as possible. The agenda for today is to look at a bit of a background to the Act, and then the timetable for all of the changes, who and what it affects, and then we'll look in detail at some of the changes taking place on the 28th of June. And then future changes, because this is being spread over a few years, and then we'll come back to your questions. So as I say, do get in touch with us on those questions. And that's just a quick notice to say this is general information as opposed to specific legal advice, and some of these issues I touch on are quite complex and you would need to take specific legal advice. So let's look at the background to the Act, and it is of course significant that yesterday was the 5th anniversary of the Grenfell Tower fire, in which 72 people died and 70 were injured as a result of that disastrous fire at the Grenfell Tower. And that incident led to Dame Judith Hackett being appointed to carry out a review of fire safety in flats, and having carried out that review, the government took into account those recommendations and published a policy document, Building a Safer Future. That policy document was consulted upon and eventually led to the publication of a proposed building safety bill, and that was published in July 2020. That was looked at and scrutinised, and it was eventually brought in to Parliament in about July 2021. The Act went through all the various stages of Parliament and received royal assent on the 28th of April 2022, so it's a very recent piece of legislation. Between presenting the bill to Parliament and it actually being passed, there were a large number of amendments. So if you've been looking at information from 2 years ago, it could well have changed. The other issue is that the Grenfell Tower public inquiry has still not been completed. The report hasn't been published, and therefore it is likely that there will be significant other changes and recommendations following publication of that. Now, if we have the next slide, there is, as I say, an 18-month period for changes. The first set of changes, the ones that we're mainly going to look at, come out 2 months after the royal assent, so those are due to come into effect on the 28th of June, 13 days time. And then another set of changes will come in 12 months after passing, so 28th of April 2023, and then the final changes hopefully by the 28th of October 2023, 18 months after the passing. All of it set in the timetable says that they will be done within these time periods. That's what is hoped. But you should note that the dates depend on secondary legislation being passed, and if that is held up for whatever reason, then that could delay, or in fact if they're passed quicker, then it may come in sooner. What I should also say is there's a published timetable for these events, but some of the changes that occurred aren't on the timetable, so we're not quite sure when it's intended that they come in. So, for example, as I've put there, the new build homes warranty, which we'll talk briefly about a bit later, is not on the timetable. Who and what does the Act affect? Well, it affects everyone involved in planning and construction of all buildings, really, although a lot of the Act is aimed at blocks of flats or higher risk dwellings, as it's known. It does cover other properties as well. And it's not just those who plan, design and build, but also manufacturers have been included. And so that's a significant extension. It also has a second stage, and we're looking really about how the Act affects construction of buildings, but the Act also deals with how safety is controlled in these buildings when they're actually occupied. So there's law relating to occupiers and managers of dwellings. There's taxation measures to raise money to pay for various matters, and so this increases the costs for developers. It increases the rights to make claims and what the claims are actually for. As I say, a lot of the Act only applies to higher risk buildings, but as I explain later, be careful because that definition may change. As I say, it does include other residential properties. This was a significant piece of legislation. There's 6 parts, 11 schedules and 171 clauses, and there's countless pieces of secondary legislation that will be passed to bring all of what is planned into effect. So let's have a brief look at higher risk buildings. As I say, there's a lot of the Act applies only to these buildings, and there's 2 definitions. The first definition is buildings that are at least 18 metres high or at least 7 stories high, and are specified by the Secretary of State. So it's a type of building specified by the Secretary of State. The specified buildings haven't been completed yet, what they are, but the proposals are those buildings with at least 2 residential units, so flats, although it'd be some considerable 1 residential unit if it was 18 metres high, care homes and hospitals. So those are the only proposed specified buildings that would be including as high risk buildings for construction purposes. The second definition relates actually to management of risks when the properties are occupied, and they are therefore limited just to 18 metres high or at least 7 stories and at least 2 residential dwellings. So we are looking at blocks of flats. The reason for this is it's not that other the legislators don't care about the other types of building, it's that the other types of buildings are covered by other regulations when they're actually occupied. What you should know is that this expression of higher risk building is used in a number of other pieces of legislation and regulations, and the definitions aren't consistent. And so you have to look at each definition depending on which regulation or law you're looking at, and they can also be changed by regulation change rather than an Act of Parliament, and may well change. For example, there's a lot of pressure saying, well, actually it shouldn't be 18 metres high, it should be at least 11 metres high, So London Fire Brigade, for example, says that all of their equipment actually is for 11-metre high buildings, not 18-metre high. That's where it becomes high risk. So that may change. So having given some background and information and context as to these changes, let's have a look at some of the changes that are due to take place on the 28th of June. So these are in effect changes that could be brought into effect quite quickly. And the first one I'm going to look at is the extension of limitation periods. A limitation period is the time that somebody has to commence proceedings in court to make a claim. Now, most of the time, those limitation periods for construction-related works would be either 6 years or 12 years. There might also be a limitation period of 3 years when you knew or ought to have known of a potential claim. So it would be 6 or 12 years from the date the cause of action arose. So that's the normal limitation period. Now, this extension of limitation periods applies to particular claims only. The Defective Premises Act from 1972 gave a cause of action for people who bought properties or dwellings which were, when built, unfit for habitation. So this related to new builds. So if something was built which wasn't structurally safe and was therefore unfit for habitation, you could claim against the builder for the cost of remedial work. It's only applied for new buildings, new dwellings, but this has now been extended to existing dwellings. So what that means is that if you get in a builder, as an example, to do a large extension and they make the building structurally unsafe, so it's unfit for habitation, you could sue them under the Defective Premises Act. Now that you might say, well, I'd have a contract to sue them under there anyway, but if somebody sells it on so that there's no contractual claim, you could still claim under the Defective Premises Act. The Building Safety Act also brings in one of the sections under the Building Act from 1984, and this has now come into effect so that you can also claim for damages for harm caused as the building does not comply with building regulations. So the building's put up, it doesn't comply with building regulations, it causes harm, and therefore you can make a claim. Now, it's not quite clear whether when we say damages for harm, that only relates to personal injury claims. It may do, but it may also be possible to claim for all types of claims. So again, the cost of repairing a building. The Act has also brought in a right to claim against manufacturers of products that are used in construction. So if those products actually breach the building regulations and they cause the building to be unfit for habitation, you can claim directly against the manufacturers. So, for example, if a builder had gone into liquidation, so you couldn't make a claim, you could claim directly against the manufacturer. So these are big changes to the types of claim you can make. And if we move on to the next slide, I set out what the extended periods are. So claims under the existing possible claims under the DPA, so that's not the claims for existing build dwellings, it's for new builds, has been extended back to 30 years. So you could make a claim if you bought a new house that was unfit for habitation built in 1992, you could claim against the builder. There is also a specific extension of the limitation period for 30 years for cladding manufacturer claims. So any of the flats that were built with similar cladding to Grenfell Tower, you can claim against the manufacturer for those materials going back to 1992. For new claims that arise, so claims that arise after the 28th of June, the limitation period is 15 years. So it's not 6 or 12, it will be 15 years. So a longer time period to make a claim. There is an issue, obviously, that limitation periods run out exactly 12 years after they accrue, or 15 years now, or 30 years. And so with the changes coming into effect on the 28th of June, some claims will run out on the 29th of June. Obviously, that's a bit unfair. So all claims that would have arise within that first year after the Act coming into effect have 1 year to run. So anyone who has a claim has 1 year to commence those proceedings, and they won't suddenly run out. Now, with regard to these particular changes, you might want to think about, do you have to do anything, particularly going forward, because actually you may have contracts that say things like you can only bring a claim within 12 years of practical completion. Your collateral warranties might say that as well, that claims within 12 years of completing the subcontract works, and therefore would you be able to make claims if the claim arises between that, say, 12-year and 15-year period. So it might be that you would want to look to amend your contracts. Insurance requirements is also stated often to say that you'll insure for the next 6 years after completion, or the next 12 years. Again, you might want to have a requirement these are provided for 15 years now rather than 12 years. There is some debate that you could still be able to make claims against another party if you wanted to outside that period, even without these extensions. But you might think it's safer just to extend contract periods to 15 years. Further changes on the 28th of June, which are quite significant, are building liability orders. Now, this is quite an unusual concept in English law because people set up limited liability companies or limited liability partnerships, and that protects them from claims. You have to claim against those specific companies, and it's actually difficult to go through what's called the veil of corporation and go after other shareholders or members of limited liability partnerships. And these, what happens in construction cases is if you're developing a single site, you will set up a special purpose vehicle, an SPV, and that then protects a group company from civil liability. And therefore, what happens, it would happen is, will these claims be made, will it be possible to make these claims against those SPVs? Because often what happens is the SPV is set up, it makes its profit, sells the site or the development, and then closes down. So building liability orders have been brought down to avoid civil liability being lost. And this means that liability can be extended to associates of the SPV, and associates would include a parent company. So that's a company with that owns the majority of the shares, if not all of the shares in the SPV, or a sister company being a company that has shared ownership as the SPV. So the group company may not have any assets, but there may be a sister company that has assets. So building liability orders can be made to make those other companies pay for the liability of the SPV company, so it is quite unusual. It only relates to certain claims though. So the Defective Premises Act claims and the Building Act claims that I've talked about, those are claims that you can make, use the building liability order for. Also claims where there is a building safety risk, meaning that there is a substantial fire or structural safety risk, and therefore those defects have to be put right. So those claims can also be included in building liability orders to recover the cost of carrying out those works from those parent or sister companies. Now these changes are effective even if you close down the original company. So if that SPV is quickly closed down, profits taken out, you don't just avoid liability by doing that. This does reduce the incentive to use SPVs slightly, but in fact, because it's quite a limited range of claims that can be made, the use of SPVs won't stop, and there's significant benefits which probably outweigh these risks even after these changes. Also, changes on the 28th of June. These are really preparatory changes. So the building safety regulator is being set up to govern construction works, and the health and safety executive is going to be the home of the building safety regulator. They're going to be a part of a different department in the health and safety executive. So the rules have been, the laws being brought into effect to set them up, and it's hoped that the building safety regulator will be effective within 18 months. And I set out some of the role of the building safety regulator. It's to introduce and also enforce stringent regulations for higher risk buildings, because we don't want another Grenfell Tower again. And that would include supervising building control. But their remit is not limited just to the higher risk buildings, it's for safety in all buildings. And whilst the earlier definition of higher risk buildings included limited numbers of other buildings, it really does mean all buildings, so factories and such like, and offices. It's also to ensure competence in building control, and then also to lead prosecution of offences, and the Act will bring in several other offences. So both civil penalties and criminal offences will be prosecuted by the building safety regulator, and that's a significant change, but we won't really see the effect of that for another 18 months. Another issue or change on the 28th of June relates to architects and architects' competence. It was found that architects, although they have quite a long qualification procedure, once they had passed all of their qualifications, there was no requirement for ongoing CPD, etc. And what therefore has been done is a requirement for architects to be regulated, and for the Architects Registration Board to be set up to regulate architects. They will then set the criteria for architects, what they have to achieve and what they have to continue to do. So as an example, it may be a requirement for them to produce, to attend continuing professional development and to record points, which lots of professionals have to do, to prove that they're keeping up to date with changes in the law and building requirements. And if they don't comply, then the Architects Registration Board will be able to take action and remove people or take other steps, no doubt, if an architect fails to meet the criteria, or if there's misconduct or serious incompetence. It's also likely that there's going to be further proposals in autumn of this year for the regulation of architects and what architects will need to do to keep their registrations going forward. So those are the most significant changes that are taking place on the 28th of June. But as I said earlier, there are considerable changes that are likely to take place over the next 18 months at least. Within 12 months, there's some changes relating to construction products and management of the buildings when occupied. So we're looking at regulation of all construction products. At the moment, there's about 400 products that are regulated, but it's hoped to increase this to all products involved in construction. So that's going to be a mammoth task. And what they're looking at is bringing in new civil and criminal offences to deal with breaches of the regulations, and if products aren't compliant with the building regulations and other regulations, there'd be more power to fine people, civilly or criminally. What's interesting is that there has been pressure on both the builders, developers, to sign up for a fund to pay for existing buildings that need to be remedied, or to agree to carry out works to the buildings that they already built. And there was a lot of the same pressure on the manufacturers. A lot of developers have signed up to a scheme, but the manufacturers haven't yet, which is quite interesting. Also, management of buildings when they're occupied. Again, very briefly about that, that relates to fire risk. You're going to have a fire risk assessment for every building, and there's going to have to be a responsible person, and they're going to set out the duties. But that's really not what we're talking about construction. That's about occupation of the buildings. So that's really outside the remit of this. So within 18 months, the bulk of the remaining changes are going to come about, and you might say, well, why is all of that time needed? It's been 5 years already since Grenfell. Well, part of it is, of course, that there's a huge amount of regulations that need to be drafted, but also the industry has to be in a position to be able to comply with them. There's no point in bringing in a law that nobody can actually comply with. And so this will give the time for the industry to be able to change. Lots of changes have already taken place. And also let's hope that some agreements will be made with the manufacturers, as I've just alluded to. Let's look at some of the changes that will occur. So one of the changes, and I'll skip through these because the detail will come through in due course. The building safety regulator is going to be in charge of managing building control, so that's building inspectors or approved inspectors who check that buildings comply with building regulations as they're being built. So they're going to be in charge of controlling that and putting up a register, as I put further down, registration of building inspectors and building control approvers who will approve what's being proposed and then inspect the building as it goes up. They're going to be regulated by the BSR. There's also a gateway regime for development, so there's going to be 3 gateways that people will have to go through to get a development through, And at each stage, you've got to look at building safety and say why the building complies with all of the safety requirements. Gateway 1 is just before you go to planning and part of the planning process. Gateway 2 is when you commence, is the gateway you go through to just before you commence development. And then gateway 3 is when you complete the development. So these will be stages that you have to go through, as I say, very much looking at building safety. And an important part of gateway 2 may well be the building safety levy. This is being proposed that there will be a levy to be paid probably at gateway 2, and if you don't pay it for whatever reason, you won't get gateway 2 approval, and so you won't be able to carry out the construction work. Building safety levy at the moment it's proposed really relating to higher risk of buildings only, and what that fund is going to be used for is for what's called orphan buildings. So that's buildings that are currently built that are defective, need remedial work carried out, but there is nobody who built it still in existence, and therefore there's no one to pay for those works. So that's what the building safety levy will be used for. Another change is the golden thread of information, which is collecting all of the information relating to safety and how you design and develop a building from day one. So from the first day that you have an idea about let's build that there, you start collecting this information so you can see the thread of how it develops all the way through. So that's quite an important concept. Some people use building information modelling, so BIM at the moment, that carries a lot of information, but it's being suggested that this golden thread will be even more than that. It might be based on BIM, but will be requiring more information. There's also a proposal for the new Homes Ombudsman to be set up. So this will enable people who buy houses, new builds, rather than going to a developer, to actually be able to go to the Ombudsman and say the house is defective, they haven't done anything about it, make a decision for me. So you don't have to go through court proceedings, so it'll be cheaper. It might be quicker as well. So that's a scheme. Part of the issue with that is that somebody has to usually pay for the Ombudsman, so they're going to have to work out who pays for that. And then also new build homes warranty, which is an interesting one because most people will say, well, all new homes come with a new build homes warranty, and that's not actually a statutory requirement, and so it is actually possible to have a new build home without such a warranty. The only thing is, though, that a mortgage company wouldn't allow you to, wouldn't lend on it. So that's why they're almost always in place. So this is going to become a statutory requirement. It's not quite clear when. And as you can see there, these new build home warranties will be for 15 years. Obviously, that 15-year period it comes into accord with the earlier 15-year limitation period, and that's probably why they picked 15 years. But 15 years is not what the current market is. The current market is actually 10 years. And so this is going to be an extra 5-year period. And we will have to see who's going to pick up the cost of the extra warranties period, because no doubt the people that provide these will want extra monies to cover that other 5-year period. So there are many other changes that are coming in construction. As I mentioned, the Grenfell Tower public inquiry hasn't reported. Also, building regulations are changing. So building regulations have recently changed, which will come into effect at the end of this year, about particular types of cladding on buildings and what can and can't be used. So those are always being changed. And the Building Safety Act does allow changes by secondary legislation. So that's often Secretary of State passing regulations. And even the items that I've highlighted today could change. And it is things like the definitions of higher risk buildings that could well change, and therefore the scope could be increased to not just large blocks of flats, but smaller blocks of flats, and then even individual residential homes. So people really have to keep on touch of this. And I think my final slide is, there are many changes occurring. I've highlighted just a few of those, and you do need to consider the current position of your contracts and whether or not they need to be reviewed, amended, limitation periods changed, insurance considered, and so do have a look at that, and please do keep up to date with the changes. There is going to be a whole raft of regulations between now and 18 months time, and if you don't keep on in touch, part of this is to make people more responsible, and it could lead to more civil and criminal prosecutions taking effect, and you obviously need to avoid that if at all possible. So hopefully that's a quick run through the major features of the Building Safety Act, and particularly the items coming in on the 28th of June. Before we take questions, we just to mention we will be sending a recording around to everyone that signed up today's webinar tomorrow morning. And also you'll see there's a link there for a survey, and we'll include that link. It's a very short feedback survey, and I'd really appreciate it if you could complete it so that we can make sure that our future webinars are helpful to you. I did see where people have signed up that there are areas that people would like us to cover, and we will try and do that in future seminars. As I said at the start, this is one in a series of Wednesday webinars. Our next webinar is an employment law update on the 29th of June. And there is also one on commercial rent arrears, when they are recoverable and how to enforce. That's dealing with the changes as a result of COVID and those restrictions that were brought in, and how they've now been removed. And there's also one there on intergenerational planning on the 7th of September. So if you are interested in those, please visit our website or our Eventbrite page and sign up. So I'm not sure if any questions have come in, but hopefully there have been some. So let's take some questions.
Thank you, Peter. We do have a couple of questions. The first one is, due to the limitations period changes, should I be amending the limitation period for past contracts and collateral warranties?
Well, it would probably be a good idea to do that if you can do that. Unfortunately, the point, of course, is that past contracts have already been signed and agreed, and you are therefore in effect stuck with what was agreed. So those limitation periods of 6 years or 12 years are in place and are stuck. So if you are a contractor and you wanted to try and sue your subcontractors, it may be difficult to do it under contract, But there is a possibility that you would be able to use, if you did have claims against you, you would be able to pass on those claims under the Contribution Act, so that you can claim a contribution to your liability. The issue with that is that those people that you're claiming for would also have to have had the same liability that you've just settled or you've been sued for. So that is a possibility, but I'm afraid if somebody comes along and says, can I extend that limitation period for the contract that we entered 3 years ago or 12 years ago, the answer is probably going to be no, and so you'll be stuck with what you've got.
Thank you, Peter. The next question we have is, my defect liability period is only 12 months, so how does this affect me? Okay, so this is a bit of a confusion that often happens with defect liability periods in contracts. People think that the defect liability period is how long a person is liable for the defects, and the defect liability period is often 1 or 2 years at most, and people think that after that period has run up that you're no longer liable for defects, but in fact it's really just a way, one, to get somebody to come back to site to carry out defects, and in that appear soon after completion of a building, and also it's about releasing of retention. So retention is a small amount of the contract price that may be held pending defects being remedied, and so the defect liability period, once you've dealt with all defects that appear in the first year, you then get your money, or the retention is released to you. So that's really what it's about. It's not about limiting liability. So if a major defect appears in your work after 3 years, you're going to be liable for that defect. And so I'm afraid that your defect liability period won't assist you. And therefore, if you're carrying out works which would make an existing building or a new home uninhabitable, then even if those defects only appear 15 years after you actually carried out the work, then you could still be liable. The defect liability period doesn't help you. Thank you very much, Peter. That's all the questions that we have for today. Okay,
well, thank you very much for those questions, and thank you for joining us today. If you do have any questions that you haven't sent in and would like to send them in, please do feel free. There's my contact details. Always quite happy to answer any quick queries or have a brief chat on the telephone about any legal issues that you have. Thank you for joining us. I hope you have found the talk useful, and have a good evening. Thank you very much. Goodbye.